The key thing, I suppose, is in Chapter 7, where if you've done a fraudulent transfer during the 1-year period prior to filing the petition, then you become ineligible for a Chapter 7 discharge. So that's a pretty serious one right there. It does play a role in a different sense in Chapter 13, in that if you've done that fraudulent transfer, then the value of the asset that was transferred goes into that Chapter 7 liquidation requirement and is used to determine at least one of the factors. It's used to determine how much you're going to have to repay your creditors. And if that fraudulent transfer involved an asset that was worth a lot of money, then you might not have the income to be able to support a Chapter 13 plan to be able to repay that to the creditors. I will say as a side note, you do not have to pay more than 100% to your creditors. So if the fraudulent transfer involved an asset that was worth much more than your total debt, well, it doesn't mean that you're going to have to pay back more than 100%. But it could jack up your plan payments up to 100%, and that might be something that is infeasible based on your income level. A similar analysis comes up in Chapter 11. There is an additional wrinkle in Chapter 11, and that is an individual debtor will not be eligible for a Chapter 11 discharge if three things are met. One of those is that the individual debtor is ineligible for a Chapter 7 discharge. There are a couple of other things that we're starting to get into something that's a bit arcane here. But if you are ineligible for a Chapter 7 discharge because of a fraudulent transfer, that could easily mean that you are ineligible for a Chapter 11 discharge as well. So I keep saying it, it's really true. Don't do fraudulent transfers. And if you've done them, give me a call. Let's see if we can't come up with a strategy to at least mitigate the problem and perhaps even undo the problem.